do not want to press the bail application, you don't press it. I will dismiss it as not pressed. You can't have both ways, no? Before the Honorable Supreme Court, you will say that the cases are not being taken. Sorry?
Deposition report. After filing of this.
नहीं, ऐसे मेंशन करके नहीं होगा कोई भी चीज.
नहीं
करना है तो आपको उसको डिसमिस एज नॉट प्रेस्ड करा के आप 6 महीना बाद, साल भर बाद जब भी मन हो करिए.
From daily statutory BA 8758 of 2025.
Passover, सवा 2 बजे. You see these Passover matters, कोई adjournment request नहीं आएगा, कोई नहीं आएगा कोर्ट में, हम डिसमिस कर देंगे. I'm telling, making it very very clear to everybody. यहाँ पर ऐसे ही नहीं टाइम होगा, ठीक है?
Item 30 BA 9672 of 2025.
Passover.
Item 14 BA 9676 of 2025.
Passover.
Item 15 BA 9884 of 2025.
Short Passover नहीं होगा, सवा 2 बजे. Passover matters will be taken up at 2:15.
Item 16 BA 9947 of 2025.
Passover.
Item 17 BA 9962 of 2025.
Passover.
Item 18 BA 9960 of 2025.
Allegation under section 72, 74, 127, 351, 2, section 42 of POCSO है. Not named in FIR, name transferred on the basis of confessional statement of Govind alias Sonar Bodra. This petitioner was put on TIP. He was not identified as per TI chart. I have
इसका और भी रिकॉर्ड होगा, देखिए.
रिप्लाई टू काउंटर एफिडेविट में TI चार्ट ले रहे हैं. उसमें है कि इस पे पेज नंबर 9 पे है.
यस, 9
पेज नंबर 11. पेज नंबर 11 पे है. 7th कॉलम में है कि विक्टिम इसको आइडेंटिफाई नहीं किया है.
7th कॉलम.
7th कॉलम नीचे से है नॉट एप्लीकेबल. पेज नंबर 11.
हाँ, ये साइन है.
इसमें कुछ डिपोजिशन हुआ, उसको भी रिकॉर्ड पे लाना, इसलिए टाइम लेना. विक्टिम का भी डिपोजिशन 27 को है कि उसका भी हुआ है.
ये नीचे क्या लिखा है?
जिसमें जिसको पीड़िता रेप करते परेशानी है, उसका पेज नंबर 6 पे है. और नीचे से देखिए, पीड़िता ने संदिग्ध को पहचान उसके साथ बलात्कार करने के को की है. उसका पेज नंबर 7 पे भी है. जो
नीचे है नहीं, है ना? ये नॉट एप्लीकेबल. ये नॉट एप्लीकेबल क्यों?
मेरे ऊपर से जो है पेज नंबर 6, 7, 8 तीनों को आइडेंटिफाई की है रेप करने के लिए. पेज नंबर 9, 10, 11 ये तीनों को है कि ये लोग को नहीं आइडेंटिफाई. स्पेसिफिक गोली है. नीचे से पीड़िता ने संदिग्ध को पहचान, जो पेज नंबर 6 पे है. एक्यूज मैरियम मरियानुस बोदरा, इसको आइडेंटिफाई किया कि ये रेप किया है. पेज नंबर 7 पे है सोनल बोदरा उर्फ गोविंद, इसको भी पीड़िता ने संदिग्ध को उसके साथ घसीट कर ले जाते हुए बलात्कार किया था, इसलिए पहचान की. पेज नंबर 7 पे भी है मरकुस बोदरा, पीड़िता ने संदिग्ध को उसके साथ बलात्कार किया था, इसके लिए पहचान की. पेज नंबर 9 पे है नेल्सन बोदरा, नॉट एप्लीकेबल, इसको नहीं पहचानी है. पेज नंबर 10 पे है फ्लोरेंस बोदरा, इसको भी नॉट एप्लीकेबल. और पेज नंबर 11 पे दिस पिटिशनर आसियन बोदरा, इसको भी नॉट एप्लीकेबल, इसको नहीं पहचानी है.
क्या बोलना है?
TI प्रिंट और इसका विक्टिम का एग्जामिनेशन 27 को रखा हुआ है।
आपको क्या बोलना है स्टेट?
जब इसमें विक्टिम का स्टेटमेंट दिया गया है इसमें बोलते हैं और उसने एफआईआर
नेम्ड इन एफआईआर किसी नेम्ड इन
नॉट में
बताइए जरा एफआईआर में कहाँ नेम्ड? यस, वेयर इज ही नेम्ड इन एफआईआर?
सबका अज्ञात अपराध करने सब किसी का नाम नहीं है एफआईआर के सेवन
उनको नहीं बोलने देंगे। आपने बोला नेम्ड इन एफआईआर है ना?
जैसा पर एक में होते
8 ऑफ द बेल एप्लीकेशन।
दूसरा इस केस का आसियन बोलता सीरियल नंबर 18
आप हैं क्या 18 में? हाँ बताइए। इज द पिटिशनर नेम्ड इन एफआईआर?
इस केस में ना 19 15 में जो एक सप्लीमेंट्री फाइल किए हैं सप्लीमेंट्री मुझे देखा गया पेज नंबर 1 है।
हाँ ये संदेह।
हाँ इसमें जो इनका नाम मुझे आया वो 19 15 का इनको आइडेंटिफाई जो किया गया
कहाँ आइडेंटिफाई किया है?
अच्छा
कहाँ कौन सा कॉलम से बोले कि आइडेंटिफाई किया?
किसी पहचान के जिससे
गवाह ने बोनी धान की पहचान की।
बोनी धान की
ये बोनी धान तो नहीं है,
जी
नहीं आइडेंटिफाई किया ना?
नहीं
बस ठीक। BA नंबर 9963 और 25। बाकी फॉर्मल आप कर देंगे, ठीक है? The counsel for the petitioner has submitted that. The petitioner is neither named in FIR nor the victim has identified the petitioner during TIP. Counsel for the opposite party has submitted that the offence is of serious nature and it's of gang rape. Correct? However, considering the fact that the petitioner is neither named in FIR nor has been identified by the accused in TIP, and it appears that some of the accused have been identified by the petitioner,
by the victim.
By the victim. The petitioner is directed to be released on bail. Who would be the bailer? Who would be the bailer?
फैमिली मेंबर
कौन है आपके यहाँ पे, कौन आए हैं?
उसका रिलेटिव
कौन रिलेटिव है?
वो रिलेटिव लिखा हुआ है फैमिली मेंबर को
One of the bailers should be the
क्लोज रिलेटिव
deponent to this affidavit. एक तो इन्हीं को बेलर बनाइए, ठीक है? And the other bailer should be his close relative. The petitioner is on the following conditions. Conditions हम लोग का वही general है, that you will furnish your mobile number and you will appear on every date. In case of default even in one date, your bail will stand automatically cancelled.
Item 19 BA 10012 of 2025.
Yes? That's okay.
Item 20 BA 10050 of 2025.
We have added section 18 of BLS, that is dowry debt. There is an allegation against the petitioner that petitioner, his wife and brother, all the three persons, they have lured the deceased.
Within a year she has been found dead.
No, but the allegation is that this petitioner, his wife and his brother, all the three persons they have lured the deceased to solemnize marriage with the petitioner.
So
This allegation is hard.
marriage was solemnized.
No marriage was solemnized. There is only this allegation has been made. The case diary and
Is
postmortem
it your
report was
case that no
confirmed.
marriage? She's not your wife.
Yes. No marriage. There was
She
a love
was.
affair.
Her dead body was found where?
The dead body was found.
In your house, right?
Yeah.
Died of strangulation.
No, there is an allegation that there is a, but the postmortem report does not say
Postmortem
so.
says so.
Postmortem says death is due to arrest of death is due to cardiovascular arrest due to neck compression.
Neck compression,
and not by hanging.
That's right. Not by hanging.
Not
But
by-
you were found hanging. She was found hanging in your house. What else? केस
But
नहीं है,
it was
बेल का केस नहीं है, प्लीज
Two
नॉट
documents were already granted. They have been granted anticipatory bail.
नहीं औरों का हम नहीं जानते हैं. You are the person, no, before with whom she got married.
There is
As
an
per-
allegation, yes, as per the affair, that's it.
देखिए, बाकी सब formal. The learned counsel for the appellant, the petitioner, has submitted that no marriage was performed, and the petitioner has been falsely implicated. He has submitted that the allegation is that the accused had allured, accused na?
Accused,
Accused-
this petition, his wife and his brother.
Accused his, the petitioner, his wife and his brother had allured the
Deceased.
deceased to marry who?
This petition.
To marry this petitioner. You already have a wife.
Yes.
The learned counsel for the opposite party state has opposed the prayer. And has submitted that as per the allegation, the daughter of the informant, namely Sarita Kumari, was taken away by his wife Urmila Devi on 26/7/24 and got her married to the petitioner Pramod Bhuiya. He has also submitted that the victim was found, the dead body of the victim was found in the house of the petitioner, correct? In the house of the petitioner, and the cause of death is strangulation. Considering the serious nature of offence involved in this case, this court is, and that the dead body was recovered from the house of the petitioner, this court is not inclined to enlarge the petitioner on bail.
Submission is there.
All right.
Submission.
Submission लिख दिया आपको?
Like two co-accusers have been granted anticipatory bail, and so far as strangulation is concerned, there is no nail mark on the accused. No injury has been found.
No injury has been found, and she died of strangulation.
No, that is what the prosecution is.
Just a moment.
But there is no
Okay,
nail
the
mark.
learned counsel
nail mark.
submits that the other two co-accused have been granted anticipatory bail by this court. Like,
Wife and brother.
on the ground that they had no role to play, right? in APA number 6287 of 2020. Next. Dismissed.
Item 21, BA 10098 of 2025.
We don't have a copy of the petition, so I would pray to keep it
Who are you?
on behalf of informant.
Informant. Informant has no name. Yes. Sorry? सवा दो बज जाएंगे इनको दे दीजिए फाइल पढ़ने रीड द फाइल पास ओवर 250
Item 22, BA 10105 of 2025.
Petitioner is in custody since 22/5/2025. Worship, the allegation is that the petitioner and the other co-accused have kidnapped the informant and his friend and have threatened them and demanded 10 lakh rupees. Later on, they released the informant and his friend after receiving 3,50,000. Worship, the grounds are that nothing has been recovered from the possession of the present petitioner.
case diary has come where is the case diary कहाँ है
Charge sheet has been submitted.
how many cases do you have
As per the June order, Your Lordship, 6 pending cases are against the petitioner.
and from the dump CDR report you were found in the vicinity isn't it and so many antecedents you have
Lordship, charge sheet has been submitted, Your Lordship. There is no need for custodial information.
you are in jail you are not in there for custodial interrogation are you there for custodial interrogation charge sheet has been already submitted अब क्या interrogation heard the learned counsel is pleading on behalf of the parties. You were also identified. The learned counsel for the petitioner has submitted that the petitioner is innocent and has been falsely implicated in the case. There is no linkage between the petitioner mobile on any ransom call and any call for ransom. She submits that charge sheet has already been submitted. Learned counsel for the opposite party has opposed the prayer and has submitted that the petitioner has been identified by the victim and the petitioner along with other miscreants had kidnapped the informant and his informant for ransom. He has also submitted that the petitioner has as many as 6 criminal antecedents of similar nature. Has 6 criminal antecedents of similar nature. After hearing the counsel for the parties and the fact that the petitioner has been identified by the victim and the petition has numerous criminal antecedents, this court is not inclined to enlarge the petition on bail. Rejected.
Item 23, BA 10114 of 2025.
Allegation under section 310 and 311 of the INS Act. Allegation of targeting. So allegation in fact that informant is the loan recovery agent. While he was returning, in the meantime, 2 persons come on the motorcycle and they stop the informant. In the meantime, 4 other persons come on the motorcycle. They looted this informant 35,580 rupees and mobile phone and 1 tag has been looted by the accused person. In course of investigation, one of the co-accused, namely Lal Mohan Munda, has been apprehended by the police on the basis of secret information. He confessed the name of this petitioner and other co-accused persons. Those are involved in this matter also. And on the basis of the confession, one co-accused person has been granted anticipatory bail and as per the allegation against this petitioner.
Who has been granted anticipatory bail?
One of the co-accused whose
नाम बताइए.
name is Paleswar Munda. His name also come in the confessional statement along with this petitioner also.
Which is the order of anticipatory bail? Yes.
As per the allegation against this petitioner, along with the one co-accused, namely Sahinder, has been arrested by the police. Sahinder Mali has been arrested by police. Thereafter, police recovered one country-made pistol and 2 live cartridges from the position of the Sahinder Mali. And from this petitioner lordship, 1 bag and 1 black glove.
Entire belongings of the informant has been recovered from your possession. How your case is similarly situated?
Not similarly situated. Name come on the basis of confession both.
But it is recovery from your possession.
It is a recovery from the confession of the two. There are joint confession. Recovery was on the basis of the joint confession. See, Lal Mohan Munda was.
What is the place of recovery? Place of recovery.
Place of recovery is the जंगल में एक जगह से रिकवरी किया गया as per the FIR.
रिकवरी किसने कराया? आपने कि किसी और ने?
तो 2 जन का नाम है सीजर लिस्ट में. लाल मोहन जिनका सबसे पहले जो अरेस्ट हुए थे उनके कन्फेशन में मेरा नाम है, उनका भी सिग्नेचर है और साथ में मेरा भी सिग्नेचर करा गया है. Subsequently I have been arrested. It is come in the case that कुजयंबा से करीब 1 किलोमीटर दूर पर जंगल के समीप पहुंचा तो वहां वादियों के पास से लूटे गए सामानों को छुपा कर रखा गया था.
ये कौन लेके गया वहां?
ये पुलिस लेके गया.
किसको? आपको लेके गया कि नहीं?
वादियों को.
आप थे कि नहीं?
It has not come in the case diary.
It is
पारा 48 में भोला सिंह मुंडा एंड लाल मोहन सिंह मुंडा दोनों के हिसाब देंगे.
और आप कौन है?
हम हैं भोलानाथ
भोलेनाथ सिंह मुंडा. आप ही तो गए हैं?
It has come in that both have been
यस. दूसरे को बेल हो गया लाल मोहन सिंह मुंडा?
नहीं पेंडिंग है.
और 87 में इंफॉर्मेंट अभी भी फाइल किया है जो लूटेड आर्टिकल रिकवर हुआ.
87
Yes. This petitioner.
वो तो recovery identified है.
As per the FIR note, informant has categorically stated that कि देखने से मैं पहचान लूँगा. But till date
TIP नहीं हुआ.
TIP is not done by this. He is in custody 17/6/2025. No criminal antecedent. He has no criminal antecedent. और 6 महीना 7 महीना से ऊपर से कस्टडी में है.
The learned counsel for the petitioner. The learned counsel submits that the petitioner is not named in the FIR, and the allegation is that a number of persons had looted money and other articles from the informant, who is a recovery agent. He submits that in the FIR it has been mentioned that he would be in a position to identify the informant would be in a position to identify the accused person, but no TIP has been conducted so far. He has further submitted that a co-accused, namely Baleshwar Munda, has been granted anticipatory bail by this court in ABA number 6109 of 2025. The learned counsel for the opposite party has opposed the plea and has submitted that the looted articles have been recovered at the instance of the confession statement of two co-accused, Bholenath Singh Munda and Nalmohan Singh Munda, and which is apparent from the jungle and those items have also been identified by the victim. Yes. इनका confession statement कहाँ record किया? Your confession statement has also been recorded.
Recorded.
Where is it? भोलेनाथ सिंह. आप ही का पहले record हुआ.
बोला ना.
Your confession statement is recorded prior. आपका confession statement record हुआ है?
लालमोहन मुंडा has been apprehended by the police.
नहीं, आपका confession statement पहले record हुआ.
Para 26 और लालमोहन का है
Para 26. लालमोहन का बाद में.
Yes, I have been arrested later on. Lalmohan. I have been arrested. पहले लालमोहन साहब arrest हुए para 24.
Confession statement तो आप ही का है पहले.
It has been taken my confession statement prior, but at the same time, confessional statement has been taken both accused person. Lalmohan Munda केस डायरी में है, पहले दिखा दिया गया है, but I have been arrested later on the basis of confession of Lalmohan.
कहाँ से बोलते?
para 24 में है कि लालमोहन मुंडा पकड़ाए थे. पारा 20 तो फिर उसके कन्फेशन पे पारा 25 पे भोलेनाथ सिंह मुंडा को थाना पहुंचाया। उन्होंने बताया कि मेरे साथ भोलेनाथ मुंडा भी थे। Charge sheet has been submitted. The charge has also been framed.
No antecedent.
No antecedent. No antecedent.
The learned counsel made to this, the learned counsel for the petition has submitted that first the co-accused, क्या नाम है इसका? Lal Mohan Munda was arrested, and thereafter the petitioner was arrested, and upon confession statement of both of them, the recovery was made, and Lal Mohan Singh Munda had taken the name of the petitioner. He has also submitted that the petitioner has no criminal antecedents.
Mentioned in part 17 of my opinion.
I have a criminal antecedent. नहीं है ना? After hearing the learned counsel for the parties and considering the fact that the name of the petitioner has come in the confession statement of the co-accused Lal Mohan Singh Munda, and the recovery is made by taking them jointly to the place of recovery, and the petitioner has not been put on TIP. The petitioner does not have any criminal antecedent. Considering the charge sheet has already been submitted. Bill. एक इसमें जो आपके भाई हैं शायद लेट कनक सिंह मुंडा, एक तो आपके भाई बनेंगे मेलर एफिडेविट में जिनका है, अनदर क्लोज फैमिली मेंबर, 25,000 टू श्योरिटीज, और वो यूजुअल कंडीशन रहेगा सब.
Item 24, BA 10145 of 2025.
Yes, petitioner.
The case is based on the statement given by the DSP, who was an officer in charge of cyber police station. From
Yes,
secret information, she came to learn that cyber criminals have assembled at Olive Restaurant. And when she conducted the raid, she got hold of the petitioner along with 6 or 7 other accused persons. Now, the allegation is that what these people used to do is that they used to arrange for bank accounts through which cyber fraud could be conducted. Now, in the FIR, the allegation may see, the officer has placed details of account numbers which she has stated that they are linked with 1930, that is cybercrime portal, through which frauds have been committed. And the accused name has also been
1930 skip through.
1930 is the national.
That's right.
These account numbers are have been detected at 1930's portal, and
1930 people are lodging their complaint over.
correct.
So those people who have lodged the complaint, their number is there.
Their number is there.
Yes.
Now the details are also given, the bank account details, and beside that the accused names are also given. This petitioner's name does not figure in that. What recovery has been made is that mobile phone has been recovered from him. पासबुक अनिल कुमार के पास से मोटोरोला कंपनी का 2 स्मार्टफोन, आधार कार्ड, एक आईसीआईसीआई बैंक का डेबिट कार्ड, यस बैंक का एक वीजा प्लैटिनम कार्ड. आई एम रीडिंग एट पेज नंबर 70 योर लेक्चर. एक पैन कार्ड, एक ड्राइविंग लाइसेंस, एक यूनियन बैंक ऑफ इंडिया का प्लैटिनम डेबिट कार्ड आदि बरामद हुआ है.
पेज नंबर 17 में कहाँ है?
चार्ट ऊपर में,
हाँ चार्ट ऊपर में.
उसके नीचे, उसके सेकंड वाला पैराग्राफ. उसके ऊपर ही जा सकता है।
SBI डेबिट कार्ड प्लैटिनम
अनिल
कार्ड,
कुमार, this is
अनिल
another-
कुमार नाम नहीं लिखा।
एक अनिल कुमार नाम। अनिल कुमार के पास से मोटोरोला कंपनी का 2 स्मार्टफोन, आधार कार्ड, एक ICICI बैंक का डेबिट कार्ड, येस बैंक का, एक वीजा प्लैटिनम कार्ड, एक पैन कार्ड, एक ड्राइविंग लाइसेंस, एक यूनियन बैंक ऑफ इंडिया का प्लैटिनम डेबिट कार्ड आदि बनाना हुआ है।
इसका डिटेल्स कहाँ है?
ना
सीजर लिस्ट में होगा ना डिटेल्स।
हाँ, सीजर लिस्ट
That phone number, that INE number, nothing is involved.
nothing is involved.
Charge
Now
sheet has
case
been
diary has
submitted.
been called for. There's a
Charge sheet has
confession.
been submitted. Charge sheet has been submitted.
I'm not aware of that. No victim has come forward in this case, and 6 other co-accused persons have already been
But the
granted.
objectionable app stood downloaded in your phone number, in your
There is
phone.
nothing.
There is nothing.
In the case diary, nothing has come out. Only there is a confessional statement given by this petitioner, and in which he
And
says
the modus. He only talks about the modus.
modus. That through software that has to be
Any
downloaded.
antecedent?
No antecedent.
Yes.
Lordship, I have no case diary, Lordship, but through the impugned order, I am arguing the case, Lordship. Ki on NCRP portal, the number of the several cyber criminals are reflected, and thereafter the one raid is made in the hotel's Lordship, and this petitioner apprehended with 2 mobile
That's
sales and SIMs, Lordship. And he confessed that he provided the bank accounts and numbers to the Chinese cyber criminal syndicates who made attempt to.
So he did not provide. He was making arrangement for that. Did he provide?
Lordship Power had passed detail to foreign handlers via Telegram and WhatsApp using a PK files from platforms such as Pay, Moon Pay, Super Pay once installed on the victim's phone. ये आया। Thereafter इनके मोबाइल्स में क्या पाया गया लॉर्डशिप? कि इनके 2 मोबाइल फोन, डेबिट कार्ड, ड्राइविंग लाइसेंस, पैन कार्ड along with screenshot of WhatsApp chat total 50 page. That WhatsApp chat contains that how he provided those numbers to the cyber criminal syndicates of China and other कोई भी इसके साथ कैसे कम्युनिकेशन करते थे लोग, उसका WhatsApp chat का 50 पेजेस ऑलरेडी इनका आया है।
कहाँ है 50 पेजेस? ऐसा क्या चीज है?
इम्प्यूट ऑर्डर
इम्प्यूग्ड ऑर्डर में ही अगर ये अपील थोड़ी है, आप हमको बताइए कहाँ है इनका 50 पेजेस का आपका केस डायरी आया हुआ है?
केस
हाँ, तो आप क्यों नहीं देख रहे हैं केस डायरी?
लेकिन हमारे पास केस डायरी एक्चुअली नहीं है, कोर्ट में डायरेक्ट आ रहा है।
तो आप देखिए,
देखिए इसको पासवर्ड किया जा सकता है।
2:15 बजे आप केस डायरी में देख के बताइए इनका कितना इन्वॉल्वमेंट है, इनका किस तरह का चैट है इनके फोन से। बाकी लोगों को 2 लोगों को 6 पर्सन्स को मेल भी हो चुका है। इसको पास ओवर कर रहे आप बस जैसे ही ये बोर्ड खत्म होगा ना बेल वाला, आप तुरंत देख लेंगे, क्योंकि आपको कितना टाइम लगेगा देखने में? 12 बजे करें?
देख तो सकते हैं, लेकिन आज एक्चुअली है कि इस कोर्ट से तुरंत देखा।
2:15 बजे आपको कन्वीनियंट है?
2 ही बजे
2 बजे ठीक।
Item 25 DA 10174 of 2025.
Clear for regular bail for the alleged offence under section 96 of BNS and 6 of POCSO Act. Although the charge sheet has been submitted under section 96 and 64(2) of BNS along with matter 6 of the POCSO Act. So far as allegations are concerned, it is alleged by the informant, who happens to be the mother of the victim, that prior to 10 days prior to lodgement of the case, there was a quarrel in between the parties. They are the co-villagers on the point of passage.
Yes, madam. The victim is not supporting this.
Yes, this petition is there, but in 183 statement she has supported this.
But her statement has been recorded.
PW6.
A statement has been recorded.
And even she has said that she had called the accused. No physical relationship.
She has been medically examined.
That is not there in the.
क्या ये ट्रायल चल रहा है? ट्रायल चल रहा है. What is the stage of the trial?
Matters, I have annexed these 7 depositions of the witnesses matters and rest matter.
How many witnesses are there?
I am not I don't have the information matter regarding the update matters and how many witnesses.
तो आपको इन्फॉर्मेशन नहीं है तो आपको कैसे देंगे? अगर ट्रायल फैग इन में होगा तो हम आपको देंगे.
Matters, I will get the matters, instruction matters, maybe fast for 1 or 2 or matters at 250. Exact information matter डाल.
आपको भी नहीं पता स्टेज में. She has been recovered from your house?
No.
No.
That is not.
That is not.
It appears to be a case of love affair.
What is your age?
But the age of the accused, the age of the accused is mentioned matters 20 years.
The girl is 17.
And she has said matter that कि मेरा 3-4 साल कम करके मेरा उम्र लिपाया गया. Even the brother has said my age is 28 years and my sister is 3-4 years
इसमें घुसिएगा तो बहुत मुश्किल. इसमें घुसिएगा तो बहुत मुश्किल.
जी.
ऐसे बेल देते.
जी.
BA number 10174 of 25. The counsel for the parties are present. The learned counsel for the petitioner has submitted that the victim has been examined before the court, who has stated that she had gone with the petitioner on her own accord. And the petitioner is her classmate. The learned counsel submits that the petitioner is 20 years of age. And the victim is 17 years of age. Studying in class? किस क्लास में पढ़े? किस क्लास में पढ़े? Studying in class 10.
Class 10.
Counsel for the opposite party state has submitted that the victim is a minor and there has been some altercation and ultimately she was taken up. Considering the fact that victim has not submitted the case of the prosecution, the petitioner is eligible to enlarged on bail. Usual conditions, you have to cooperate fully. 2-3 conditions हम लोग का रहता है. जो इसमें पहली कार है, he is going to be one of the bailer and one more close to 25,000 to the office.
Item 26. Item 26 PA 10177 of 2025.
Pass over करते हैं.
Item 27 DA 10182 of 2025.
Pass over.
Item 28 VA 10231 of 2025.
Yes.
Under sections 351-64-M or 65-1 of BNS and 4/6 of Oxford. Charge sheet has been submitted in this case after investigation and additionally in custody since 21
DT.16.02.2026. Actually, petitioner and daughter of informant both are having cordial relationship. They are related with two different religions. That is main dispute in this case. Due to religion, father of informant has lost this case.
Her statement has been recorded.
Yes. 183.
Statement of the victim has been recorded.
Yes, yes.
आपको क्या बोलना है? The learned counsel heard the learned counsel for the parties. The counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case, and the petitioner and the victim belong to different religion, and therefore the case has been lodged. He has submitted that the petitioner and the victim had cordial relation. The petitioner is
About 36 years.
aged 26 years and the victim is aged
15.
years. Correct? The learned counsel for the opposite party has opposed the prayer and has submitted that there is direct allegation, and the victim in a statement recorded under section 183 BNSS has supported the case of the prosecution. Considering the nature of allegation and the statement of the victim, who is just 15 years of age, having been recorded, this court is not inclined to enlarge the petitioner on bail and is rejected.
Item 29, DT.16.02.2026 of 2025.
In this case, the case diary has been called for by order dated 27th November 2025. The offence under section 103(1), equivalent to section 302 of the IPC, and 3 under bracket 5, that is equivalent to section 34 of the IPC. The FIR was registered against 3 accused persons, including the petitioner, as accused number 2. I am permitted to place the FIR not in short note, subject to lordship kind pleasure. Page number 70. Yes. सचन सर से निवासी बीते वर्ष 2024 में मेरे बहन फुलमणि मारंडी का शादी सचन सर टोला के गोविंद सोरेन पिता सुखदेव सर is the petitioner. So the son of the petitioner was married with the sister of the informant. गोविंद सोरेन एवं मेरी बहन के साथ आपसी विवाद को लेकर 2 बार सामाजिक स्तर से पंचायती भी हुई थी। आज दिनांक 8/4/2025 को सुबह 6:30 बजे लगभग फोन के माध्यम से पता चला कि मेरी बहन अचानक बेहोश हो गई। जुड़वा थाने पर मैंने देखा कि मेरी बहन मर चुकी। बातचीत के क्रम में पता चला कि अभियुक्त सचन सर, जिसमें मेरा भी नाम है, ने मेरी बहन को जान से मार दिया। इसकी सस्पेंशन सिर पर कांटी से गंभीर चोट का निशान भी है। Now you will see me kindly see the FIR on suspicion. Now you will see me kindly.
You are the husband?
Father. She was married with my son.
Yes.
Now I am the father. Now, subject to lordship's kind consideration, para 14 is the restatement of the informant. Para 14 of the case diary. Lordship just see it was middle portion. एक दो बार फुलमणि हुजूर के पास है डायरी पैरा 14 उसी एक दो बार फुलमणि मरांडी ने इसी नैहर आई थी तो उन्होंने अपने ससुराल का सारा किस्सा बताकर बताई मेरे पति गोविंद सोरेन ज्यादा शराब पीकर नशा में धुत होकर शाम को घर आते हैं और उनको मारपीट भी करते हैं। अपनी बहन फुलमणि के इस बात को कहने पर अपना गांव हदगढ़ गिद्धा के पंचायती बैठाकर गोविंद सोरेन को घर से बुलाकर कहवाए मेरी बहन फुलमणि मरांडी को नशे की हालत में बहुत ज्यादा मारपीट क्यों करते हो। इस पर गोविंद सोरेन बोले थे कि जो हो गया सो हो गया, आज से हम शराब नहीं पिएंगे, नहीं आपकी बहन फुलमणि मरांडी को नहीं मारपीट करेंगे। इतना कहने पर हम लोग गांव के गणवान 4-5 व्यक्ति बहन फुलमणि मरांडी को पति गोविंद तथा अपना ससुराल साचन साथ छोड़ 2-4 महीना भी नहीं बीता कि दिनांक 7/4/25 को रामनवमी के अवसर पर मेरी बहन अपने पति के साथ समय 7:30 बजे मेला देखने के लिए गई तो मेला में ही गोविंद सोरेन शराब पीकर मेरी बहन फुलमणि मरांडी के साथ मारपीट करना शुरू किए। वहां से मेला घूमने के बाद 9 बजे रात्रि अपने सर गढ़हारा टोला सचन साथ के वहाँ भी मेरी बहन फुलमणि मरांडी के साथ मारपीट किए। इसके बाद 12 बजे भी मेरी बहन को साथ बहुत ज्यादा मारपीट किए। आंगन में दर्द के मारे छटपटा कर अपना प्राण त्याग किया। So, it is not unlike the case under section 304B. This is the restatement of the brother of the deceased who is the informant. Now, there is no demand of dowry, no torture, unlike section 304B.
क्या करना है आपको? There is an allegation. ससुर के ऊपर कौन सा allegation? नहीं है ना, डायरेक्ट क्या कोई भी allegation नहीं।
पति पत्नी का झगड़ा में मारपीट होता था वापस।
Specific allegation है husband पर that he used to assault her after taking liquor. Or the learned counsel appearing on behalf of the petitioner, on behalf of the parties, the learned counsel has submitted that the petitioner is the father-in-law of the deceased. He submits that he has referred to the restatement of the informant
Even the affair does not say anything.
And has submitted that the restatement of the informant clearly reveals that the entire allegation was against the husband who used to assault the deceased after taking liquor.
Under the influence
of liquor. The learned counsel submits that there is no allegation of any dowry demand and there is no direct allegation against the petitioner.
He is in
Counsel for the custody since
9th April 2025.
the petitioner is in custody since 9/4/25. Investigation complete.
Completed case has been committed to the Court of Sessions.
The learned counsel submits that the investigation has been completed and the case has been committed to the Court of Sessions.
Session trial number 262/2025.
And trial has commenced.
No, trial has not. It has been committed.
It has committed to the Court of Sessions. The learned counsel for the state has opposed the prayer and has submitted that the lady has been killed within a period of 1 year of marriage.
Yes.
However, he could not point out any specific allegation so far as the husband, so far as the father-in-law is concerned. Considering the aforesaid restatement of the informant, making allegation primarily against the husband who used to assault the victim under influence of liquor, the petitioner is directed to be enlarged on bail and is custody since 9/4/25.
All right.
बाकी usual conditions रहेगा Mr. Sir.
Item 30, VA 10318 of 2025.
FIR under section 306 of IPC. Petitioner is the stepmother of deceased person. Page 13 is the FIR.
Petitioner is a stepmother
Stepmother of deceased.
of deceased. Okay. 306 IPC.
Lord.
What is the postmortem report?
Postmortem caused hanging, especially due to hanging. Counter affidavit. FIR में एलिगेशन है कि हमारे द्वारा मारपीट किया गया खाना बनाने के लिए और उसके बाद गुस्सा में बाहर गई और वहाँ से वहीं जाकर कहीं सुसाइड कर ली। यही FIR में केस है। यही है कि FIR में एलिगेशन है कि हम बराबर मारपीट करते थे, लेकिन जो ड्यूरिंग इन्वेस्टिगेशन विटनेसेस एग्जामिन हुए सभी बोल रहे हैं कि उस दिन खाना बनाने से मना कर रही थी, सिखा रही थी और नहीं सीखना चाह रही थी, इसीलिए 2 झप्पड़ मारी थी और गुस्सा में बाहर निकली। इन लोग सोचा कि गुस्साई है, थोड़ा देर में आ जाएगी वापस, लेकिन वापस नहीं है और जाकर सुसाइड।
पढ़िए FIR।
पेज 30। मैं सोनी भैया इधर नाना ऑफ द डिसीज। मैं अपनी पुत्री की शादी लगभग 18 वर्ष पहले विवाह अरुण भैया ग्राम मझौली थाना नवाब जयपुर से किया था। उसकी लड़की भी पूजा कुमारी थी, 16 वर्ष की थी। उसकी मां का मृत्यु लगभग 8 वर्ष पहले हो गया। अरुण भैया दूसरा शादी किया लगभग 7 वर्ष पहले। इसी के बाद से बराबर हमारी नतनी पूजा कुमारी को बराबर मारपीट प्रताड़ना किया करता था। आज से लगभग 2 साल पूर्व भी एक बार पूजा को हाथ में मारकर सौतेली मां ने हाथ फ्रैक्चर कर दिया था। हम लोग जाकर समझा बुझाकर पूजा को अपना घर ले आए। उसके बाद कुछ दिन के लिए अरुण भैया मेरा दामाद मेरे घर आकर अपनी नतनी पूजा देवी को ले आया और अपने घर फिर अपनी हरकत सौतेली मां राजू पिटिशनर ने मारपीट करते रहती। इसी बीच अचानक दिनांक 21/8/2023 को दिन सोमवार को सुबह लगभग 7 बजे पूजा के चाची ने फोन आया, उसने अपने नतनी पूजा देवी मर गई है, आप लोग आकर देख लीजिए। हम लोग अपने गांव मझीगांव से लगभग 9 बजे ग्राम मझौली आए और देखा कि पूजा मरी पड़ी हुई है। अपनी नतनी नाती गौतम कुमार उम्र 12 वर्ष से पूछे, बताया कि माँ राजू देवी और प्रतिमा देवी ने खाना खाते समय दीदी पूजा को काफी मारपीट किया तथा दीदी घर से भागकर पेड़ में फांसी लगाकर जान देकर माँ पहले रोज मारती थी, उसी से तंगाकर फांसी लगा। ड्यूरिंग इन्वेस्टिगेशन विटनेस एग्जामिन में चंद्रमा भैया पारा 17, 18, 19, 20 सभी बात बोले हैं कि हाँ उस दिन 2 झाप मारी थी और खाना बनाने के लिए विवाद हुआ था। खाना नहीं बना रही थी तो सिखाने के लिए मार दी थी और यही सोची इन लोग कि हो सकता है अभी गुस्सा के बाहर निकली है, थोड़ा देर में वापस आ जाएगी। बस इतना ही कोई नहीं बोला है कि हाँ पहले कोई मारपीट हुआ है, कोई घटना घटा है। और चार्ज फ्रेम हो गया है, एविडेंस स्टेज पर है। नेक्स्ट डेट फिक्स है 27/2/2026 को। कोई एविडेंस नहीं।
कस्टडी कब से?
कस्टडी हम है 14/4/2025।
सजा कितना है? सजा कितना है? 306 में सजा कितना है? Up to 10 years.
There is no instigation। यहाँ पर कोई इंस्टिगेशन नहीं है। जो 107 का इंग्रेडिएंट्स है कोई फुलफिल नहीं हो रहा। ड्यूरिंग जो ड्यूरिंग इन्वेस्टिगेशन विटनेस एग्जामिन में उस बच्चा का जिसके बारे में एफआईआर में है उसका स्टेटमेंट नहीं रिकॉर्ड हुआ है ड्यूरिंग इन्वेस्टिगेशन, जिसके बारे में इंफॉर्मेट करते हैं कि हम नाती से पूछे, उसका बयान ही नहीं दर्ज हुआ है केस डायरी में।
Yes, madam, what do you have to say?
Yes, ma'am, there is allegation and I think compared to that Market Kumar, that all the witnesses are true, ma'am.
ये सब नहीं बोले हैं कि हाथ टूटा था, ये सब नहीं बोले हैं।
As per FIR.
हाँ एफआईआर में है, लेकिन विटनेस नहीं है।
Again, the stepmother. Yes.
Stepmother भी 7 साल पहले शादी हुई।
जी 7 साल।
शुरू से ही मैंने दैट्स कम कि मारपीट होते आ रहा है।
मारपीट होते आ रहा है तो इंस्टिगेशन टू सुसाइड कैसे हो? इसको लिंक करिए। इंस्टिगेशन टू सुसाइड कैसे हो? मारपीट करते आ रहा है तो वो तो मारपीट 7 साल से झेल ही रही है। इंस्टिगेशन टू सुसाइड ऑन दिस पार्ट ऑफ द
आगे फांसी लगा ली वो मतलब मारपीट की
तो सडन प्रोवोकेशन का केस हुआ ना कि इंस्टिगेशन, अबेटमेंट का तो केस नहीं।
For the learned counsel opinion on behalf of the parties, the learned counsel for the petitioner has submitted that the petitioner is stepmother of the deceased who has committed suicide. He has submitted that the petitioner is in custody since 14/4/25 and the charge has been framed and the case is at the stage of evidence. The learned counsel submits that the biological mother of the deceased had expired and the father remarried around 7 years back from the date of the incident. The learned counsel has submitted that there is no allegation of abduction. Rather, it appears to be a case of sudden provocation. यही है आपका काम?
Yes.
Counsel for the opposite party has opposed the prayer. Considering the custody of the petitioner and that the trial has already commenced, and in the postmortem there is no external injury found on the body. Postmortem report. कोई external injury नहीं है ना?
No.
The petitioner is directed to be enlarged on bail. बाकी usual conditions. आपके husband बनेंगे bailor?
हाँ हस्बैंड बने, वही पैरिका।
The pabrika should be one of the bailor. 25,000 to sureties. Every day you have to appear and cooperate with the court.
Item 31, BA 10376 of 2025.
For the offence under section 281, 351, 274, 127, 115, 117, and 35, and later on, offence punishable under section 109 was also added. That is not been mentioned in the first. That is the The allegation part is that in the FIR is that the informant along with his brother was moving on a scooty, and one Toto driver, that is Nagendra, it is not the petitioner, he came across the vehicle and there, by hitting the vehicle, their vehicle disbalanced and both of the brother and sister fell down on the road, receiving some injuries. Thereafter, altercation started there. And in the same locality, thereafter the Toto driver called some of his men, this petitioner also. He came there and thereafter this petitioner went to intervene, but their altercation started, and it is the allegation that this petitioner has inappropriately hit the lady. Right. And thereafter they also hit the brother of the informant. And this is the case, Lashmi. Both of the sides were involved in the altercation, and the allegation is exaggerated version. Because this is the petitioner was residing there with his family. His wife and 3 sons were residing there, and they all were present when this altercation was going on. This is not the fact that any outraging modesty has been committed by this petitioner. Later on, this petitioner was in the house. They had not went to lodge the case, but there was the police suddenly arrived, apprehended this petitioner, and thereafter this case has been lodged by giving the name and address and everything detail of this petitioner. Because it's their home there. He was in his house, and thereafter this incident took place.
What is the stage?
The stage is that the case is on hearing on the point of charge. Charge sheet has already been submitted. Case is hearing on the point of charge. Next day, charge is going to be framed because they are not going to file any discharge.
A statement of the victim, etc., has been recorded.
Yes, everything has been recorded.
Before the court also.
Yes, Lordship.
Before the court also.
Yes, before the court also. And the case that was earlier called for.
What is the statement of the victim before the court?
She has repeated the same in the FIR. I have not the case diary because that has been case diary has already been called for in this court. The injury sustained by the brother has been mentioned in the order included. That is a hairline fracture of nasal bone. That is not dangerous to life. The injury is not attracting the provisions of 109 of DNS.
The nature of injury has been found to be grievous.
Grievous then 117 to voluntarily causing hurt, causing grievous injury. This is 117 to.
Yes. And what
309 is more exaggerated version because there is no any injury is that dangerous to life and there is no repetition. Both sides altercated. दोनों तरफ से मारपीट में इन लोगों को भी इंजुरी हुआ है लेकिन इन लोग चूंकि FIR नहीं किया इंजुरी नहीं हुआ इन लोग गरीब ग्वाला सब है they are having इसके पास 3 गाय और एक बफेलो हम पूछे भी इसका बेटा से they are doing all these things they are never involved कोई एक्सीडेंट नहीं है specifically stated they reside with their family there पूरा फैमिली रहते हुआ वाइफ का 3 बेटा है इसका और चिल्ड्रंस were studying उन लोग पढ़ाई लिखाई कर रहा है कोई इंटेंशन नहीं था कोई नहीं था दोनों तरफ से ऑल्टरकेशन में रिजल्टिंग इनटू दिस केस बेटा इसका फैमिली का भी है
Yes, what do you have to say, madam?
Yes, so ladies, specific allegation against this petitioner is outraging modesty of the informant. Apart from the assault made his brother, her brother. In the FIR itself.
Is it a case where both the parties they got entangled with each other?
There is no proof, Your Lordship, because they have not registered the FIR.
No, that is the allegation in the FIR itself. That they had who has been injured from your side?
My side, नागेंद्र को भी इंजरी है इसको
कहाँ है रिपोर्ट?
इंजरी नहीं हुआ कोई एग्जामिनेशन नहीं हुआ नागेंद्र को आज तक वो अरेस्ट नहीं हुआ एंटीसिपेटरी रेट फाइल किया है और ये जितेंद्र का इसको मारपीट तो इसको भी थोड़ा बहुत मुंह में
मारपीट इन लोगों ने तो कोई मारपीट नहीं किया ना आप लोगों ने मिलकर
भाई के साथ मारपीट हुआ है और इन लोग तो बोला कि वो नागेंद्र को वो लेडी भी हेलमेट से मारी है
हेलमेट से भाई को मारेंगे तो हेलमेट से तो मारेगी ना इतना तो बनता ही है
और ये कोई मतलब को एक्सीडेंट की वजह से
कस्टडी कब से है आपका
कस्टडी 8/9/2025 अबाउट 6 मंथ में वो 5.5 महीना हो गया है।
Charge sheet has been submitted.
Charge sheet has been submitted. Case is placed for framing of charge.
और अभी एक जना एंटिसिपेटरी बेल में घूम रहा है।
एंटिसिपेटरी बेल में वो उसका सिविल कोर्ट में फाइल किया हुआ है।
तब कैसे ट्रायल भी नहीं प्रोसीड करेगा?
इसका ट्रायल तो प्रोसीड कर रहा है, चार्ज केस को फ्रेम नहीं है।
ऐसा होता नहीं है ना,
स्प्लिट करके कर दिए, तो उस पर चार्ज शीट
स्प्लिट करने में भी बहुत टाइम लग जाता है।
उस पर चार्ज शीट नहीं, इस पर चार्ज शीट दे दिए, इस पर चार्ज शीट दे दिए, इनका
उसको
चार्ज
तो भाग रहा है इसीलिए अभी तक चार्ज शीट नहीं दिए हैं। क्या सिखा रहे हैं आप? ठीक है, बहुत दिन से हम ट्रिब्यूनल बेंच में नहीं बैठे।
नहीं, ऐसा नहीं।
हाँ, भाग रहा है, चार्ज शीट नहीं हुआ उसके ऊपर, इसका क्या मतलब है? इस सबमिशन का क्या मतलब है, आप हमको बताइए।
इसका चार्ज शीट का हम डेट बता देते हैं।
नहीं, हम नहीं देंगे आपको। आप फिर से आइए।
चार्ज शीट
अभी चार्ज फ्रेम नहीं हुआ है, खाली यही बोल के रिजेक्ट कर दो।
4/11/25 तो नेक्स्ट डेट पे चार्ज करा लेंगे, नेक्स्ट डेट पे तो चार्ज भी हो जाएगा, क्योंकि वो डिस्चार्ज फाइल नहीं किए हैं।
कोई बात नहीं।
4/11/25 को चार्ज शीट इनके ऊपर दे दिया गया है।
वहाँ पढ़िए तो जब इनके ऊपर जो असॉल्ट है, सेक्सुअल असॉल्ट।
In page number 18 you will
in the FIR only you read it from there.
जिसमें जितेंद्र सिंह पिता सच एंड सच, जितेंद्र सिंह ने मुझ पर लज्जा हनन करने के क्रम में मैंने सच एंड सच पर आक्रमण किया, मुझे गली की तरफ ले जाने का प्रयास किया। इस क्रम में मेरा भाई जब आया बचाने तो उस पर भी असॉल्ट एंड ही सस्टेन ग्रेवियस इंजरी।
हनुमान सिंह का अन्य अज्ञात ने मेरे भाई को गले में उठाकर लिया, जान से मारने की कोशिश की, तो लाश गले तथा हाथ को बुरी तरह जख्मी कर दिया। जब केसी राव मेमोरियल अस्पताल में तो लालपुर थाना रांची आके इस घटना की सूचना दी। केसी राव में डॉक्टर नहीं मिलने के कारण लालपुर थाना में इलाज के सदर अस्पताल रांची भेजा गया। मेरा भाई बार-बार बेहोश हुआ।
ये असॉल्ट एंड इनएप्रोप्रिएट बिहेवियर का मैक्सिमम पनिशमेंट क्या है?
उसमें 1 to 5 years है, 1 to 5 years है सेक्शन 74 ऑफ बीएनएस में, और 117(2) में चूंकि ये कलेक्टिव है, सिंगल नहीं है, उसमें 7 years है, अप टू 7 years है उसमें, और बाकी सब में कम है, बाकी सब बेलेबल है।
For the learned counsel for the petitioner, her and the learned counsel for the state appearing online. The counsel for the petitioner has submitted that one Nagendra Singh had hit the brother of the informant by Toto, and he got injured. The informant was also riding the scooty, riding in the scooty along with her brother, and thereafter there has been altercation, and during the altercation it has been alleged that the petitioner had inappropriately touched and assaulted the victim lady, and also assaulted the brother of the petitioner.
पेज 23 में एफआईआर का पार्ट है जिसमें कि ये पिटिशनर का आई स्वेलन पाया गया, आफ्टर अरेस्ट जब उसको एग्जामिन किया गया तो swallow left eye थोड़ा सा आज खुला हुआ था, क्योंकि एप्लीकेशन दोनों करते हैं।
The learned counsel submits that the allegation is the learned counsel submits that the petitioner also had suffered injury and his eyes was found swollen. Left eye was found swollen at the time of arrest. At the time of arrest?
Time of arrest was on the following day 7/9/2025.
Okay. The learned counsel has submitted that the petitioner is in custody since 8/9/2025. And he has been he has further submitted that the charge sheet has been submitted.
May I submit one thing?
And so far as Nagendra Singh is
Yes.
concerned,
That is not swollen, but it is a mole below left eye. Mole below left eye.
Examination found clinically fine.
Clinically fit.
NI, a mole.
a mole before the
A
left
mole below left eye.
लेकिन उसका पूरा चोट लगा था उसको भी इस था उसको चोट लगा था उसको
Just a moment. The learned counsel appearing on behalf of the state has submitted that there is a direct allegation against the petitioner and the informant has suffered grievous injury.
Informant के brother को injury.
This injury is an informant's brother, and the brother of the informant has suffered grievous injury in as much as there is a there is a fracture on the nasal bone.
Hairline fracture of nasal bone. Deviated nasal septum and hairline fracture of nasal bone.
After hearing the learned counsel for the parties, and it appears that the alleged incident had taken place when Nagendra Singh had hit the scooty and there was altercation. The charge sheet having been submitted, the petitioner is directed to be enlarged on bail. Your father, who would be the bailer?
बेटा का एफिडेविट किया है बेटा एफिडेविट किया है
एक तो
वाइफ के नाम से ऐसा कोई प्रॉपर्टी नहीं है तो वाइफ ही बेलर बन जाती
सन ऑफ जितेंद्र सिंह नहीं बेटा को तो बेलर बनना ही पड़ेगा
बेटा बनेगा
बेटा बनेगा और क्लोज हो जाएगा and बाकी यूजुअल कंडीशंस.
For hearing on order 41 Rule 11, Item 59, Second to 67 of 2023.
Where is the petitioner? Who is the counsel for the petitioner? Where is the petitioner? नाम का फ्लैश करें. एक बजे टेकअप करेंगे. बस ओवर कर दीजिए.
Item 60, second appeal 107 of 2023.
What was the suit for?
For declaration of title with respect to the Schedule B land, and also for declaring that the sale deed executed in between 1932 to 1949, 5 sales be declared void, inoperative and ineffective.
Yes.
And
So what is the point?
point is that the land in possession, I am the heirs of the recorded tenant. I was in possession of the land since last 100 years. And for the first time in the year 2000, they tried to disturb my possession. Then 144 proceeding initiated. Thereafter, in 2006, they again created certain portfolio, but till that date, he has not produced any deed for that my predecessors had purchased all these lands. So the land all were
The property was sold by your predecessor in interest.
They allege, I say that my predecessors had never sold the land, which is evident from the fact and Exhibit 3, which clarified that the land was mortgaged by my predecessor in the year 1949, but that has not been taken into consideration by adopting a double yardstick. Because why I am saying, Your Lordship, double yardstick in weighing the evidence of the party. This is the first substance.
Is there any legal bar in selling a mortgage property?
No, I am here in the point that two different yardsticks has been adopted while weighing the evidence of the party. If Your Lordship will see the judgment of trial court, finding running page 38, finding 37 से शुरू होता है.
नहीं, पहले रिलीफ बताइए. Relief पहले. What was the relief? Where is the trial court decree? Trial court decree कहाँ है?
Trial court decree
बताइए.
my file is
In my record also decree is not there.
the earlier advocate has filed this. Now I have been engaged in this case.
तो ये कोई excuse थोड़ी है. Earlier advocate का नाम लेकर. इसका क्या मतलब?
नहीं है तो हम इसको फाइल करवा देंगे, इसलिए कि it was not within my knowledge that the decree is not. Suit was filed for declaration. ये छोटा सा एडजमेंट कर दिया जाए.
नहीं एडजमेंट नहीं देंगे.
डिग्री जरूर पास फाइल हुआ होगा, कहे कि स्टैम्प रिपोर्टिंग में पास हुआ है. अगर डिग्री नहीं रहता तो स्टैम्प रिपोर्टिंग में ऑब्जेक्शन लगता ही लगता है.
39 का रजिस्टर सेल डीड आप चैलेंज कर रहे हैं.
32 to 49 है. 5 रजिस्टर सेल डीड है जो ड्यूरिंग पेंडेंसी ऑफ द सूट इट वाज कम टू माय नॉलेज.
आपका म्यूटेशन चल रहा था?
हाँ, मेरा भी चल रहा है.
रेंट रिसीट आपका एग्जिबिट हुआ है?
हाँ, एग्जिबिट हुआ.
एग्जिबिट नंबर बताइए.
एग्जिबिट 2 है.
एग्जिबिट 2. Where is your rent receipt?
Exhibit 1 to 1D.
कब का रेंट रिसीट है ये?
2004 to 2011 तक का है।
उसके पहले का?
एक 5-4
वेस्टिंग के बाद का रेंट रिसीट दिखाइए। वेस्टिंग के बाद का रेंट रिसीट।
वेस्टिंग के रिपोर्ट पर नहीं आया है, लेकिन ये 4 रेंट रिसीट आया है।
वो उसके पहले का रेंट रिसीट कहाँ है आपका?
उनका भी नहीं।
उनका है तो रेंट रिसीट?
उनका है, लेकिन उसमें क्या है कि दोनों हमारे पिटिशनर्स का भी नाम आ रहा है उसमें, और 1-2 में आ रहा है।
इशू दिखाइए, ट्रायल कोर्ट का इशू।
Now,
there are the issues.
Issues at page running page 31, para 6. Is the suit maintainable in the present form? Whether the penalty comports well for the issue, whether the suit is barred by law of limitation and adverse possession.
Yes.
This is important issue, but not decided in accordance with law.
That's
now 7-8 is the main issue, whether the defendant number 1 to 5 or anyone claiming under them have no right to interfere with the right, title, interest and possession of the plaintiff over disciplinary act. And subsequently, one new issue was framed as 7A because after challenge of the sale deeds. Whether the different sale deeds of the year 1932, 39 and 49 by Rupam Teli and Pannu Teli in favor of Nirmal Teli and Videsi Teli are court contributed wide, inoperative, ineffective and not binding upon. So the finding of the trial court is that since all these 5 sale deeds are registered documents, so these are presumed to be a genuine document and formal proof is not required. That's what
issue number 3 देखिए, issue number 3.
Issue number 3, whether the suit is barred by law of limitation and adverse possession, it has to be read in context with that defendant or the plaintiff.
You are not claiming recovery of
I
possession.
am not recoverable because I am in the possession.
Okay,
so I
you
am
remain in the possession. You are not claiming recovery of possession.
not recoverable.
You are not claiming recovery of possession, right?
Yes. So the finding of issue number 3 is that no case of adverse possession is made out, and as such this issue is decided. So I am not claiming possession.
No, you read, you पढ़िए ना भाई ऐसे बोलने से नहीं होगा, पढ़िए क्या finding and show me the perversity in the finding because there are concurrent findings on the point of limitation.
Yes.
बताइए. Issue number 3.
Issue number 3. From the discussion made above, it is clear that in the year 2014, the sale deed of the year 1932, 39 and 49 executed by four father operatives have been challenged. Suit filed in the year 2006 and cause of action has been shown regarding knowledge of the sale deed in June 2006. But at this stage, no challenge to these sale deeds were made, and after 8 years such amendment has been made. Further, from the evidence, it is apparent that the plaintiff has admitted that since prior to 2000 of the suit, he was aware that defendants are claiming the land on the basis of sale deeds, which got to show that plaintiff had the knowledge at best since prior to 2000, but the suit filed in the year 2006 and the document challenged in the year 2014 attack the provisions of the Limitation Act, and I hold and decide that the suit is barred under the Act also.
Where is the appellate court's finding?
Appellate court has framed two points for determination, and point number 2 is with respect to question number 2 is with respect to limitation. Para 14.
Yes, please.
The cause of action is a bundle of facts and an issue of both of law and fact. The plaintiff simply said regarding the cause of action that the defendant number 1 to 5 recently in the month of June 2006 put a bogus claim over the suit land, cast a cloud over the title of the plaintiff over the suit land as per plaintiff. The cause of action arose firstly on 25/6/2006 when the Panchayati was convened for production of documents regarding the suit land. However, from perusal of the evidence of the plaintiff and the judgment, it comes out that the learned court below has rightly appreciated the evidence by holding that one of the plaintiff as PW5 in this case at para 58 had admitted that he had no knowledge about the sale and he did not try to obtain the copy of the sale deeds from the registry office. PW5 further at para 56 has stated that the accused person was not seeking print for construction of house over the suit land. He has further stated that he has not mentioned in the print that dependent number 1 to 5 were started construction over the suit land. Dependent did not tell him that they have purchased the land from the ancestor. In this manner, the only plaintiff who came to depose before the court has failed to show any overt act on the part of the plaintiff which may give rise to cause of action of the plaintiff. It is to mention at this juncture that the present suit has only been brought for declaration of right acting in interest of the plaintiff over the suit land and for declaration that is held in favor of the defendant in respect of the suit land are forged and fabricated and not binding upon the plaintiff. The plaintiff has neither made any prayer for confirmation of position. The plaint has been vaguely drafted in manner that it does not clearly show the specific position of the plaintiff over the suit land. On the other hand, the document in shape of registered sale deed and the deed receipt in the name of the defendant clearly shows that after purchase of the suit land by the predecessor interest of the defendant number 1 to 5 was the predecessor interest of the plaintiff. The defendant are in continuous possession over the suit land. The rest of the issue were also decided as against the plaintiff after appreciation of evidence produced by the parties and the appellant had not assailed those part of the judgment in any manner whatsoever. The evidence of the plaintiff clearly shows that they were proceeding under 144 CRPC much before, at least 6 years before filing of the suit, but the suit was not referred then or within 3 years period of limitation commencing from the knowledge and the suit has been filed much after at least 6 years, which is beyond the period of limitation for a suit for declaration. Here, I want to say the suit for declaration, there is no 3 years period prescribed. For declaration, it is, I am sorry. Accordingly, this issue is also decided as against the appellant and in favor of the principal respondent. So, the appellate court has said that it is at least the knowledge, date of knowledge is 2000 when the 144 proceeding was initiated, so 6 years माना जाएगा. However, it is beyond 3 years. But beyond 3 years, the appellate court in his judgment has written within 3 years for declaration. For declaration of right title, the limitation is not 3 years. It is 12.
No, that is not the fact. The fact is that you also challenged the sale deeds, no?
Sale deeds.
As the 3 sale deeds executed way back in 1932, etc., as void. And these sale deeds were executed by your predecessor in interest. So, and you had knowledge about the sale deed. Unless these sale deeds are set aside, you will have no title over the property.
Yes, Your Lordship. That was the finding. So my submission before the tribunal was that my predecessor in interest had not sold any property. That's why it is in my possession. And for the first time, I came to know about such sale deed in the year 2006.
Heard you enough, Vicky. Heard the learned counsel appearing on behalf of the appellant.
So, Your Lordship, only contention by that the Exhibit 3, which has been filed by me, has been decided that it has been taken to be a double yardstick in deciding, because Both the documents are the registered sale deed. My documents are also registered sale deed.
No, your document is not registered sale deed. How are you claiming through registered sale deed?
No, my document of mortgage of 1949 is a registered sale deed.
So how does that make a difference? Mortgage property can also be sold. Is there any legal bar?
No legal bar, but
It is always subject to mortgage. Simple.
subject to mortgage, but that was my contention to believe that the no sale deed was executed, and at least it can be said that even if it is not a forged or fabricated document, but certainly it is an inoperative and ineffective document. And this has been ignored by the appellate court also, because these points were taken, but the learned appellate court has taken the plea that only 2 points has been raised by the appellant. That first, there is no permission of deputy commissioner was obtained, and there is a joint property, so only 1%, 2% cannot sell the property. Whereas the fact was that this point of a registered document which was ignored by the trial court was also taken into consideration. So my submission, Your Lordship, the substantial question would be whether the judgment and decree suffers from the legal infirmities on the ground of adopting double liability while appreciating the. And the second substantial question would be, Your Lordship, that whether the trial court committed perversity in not considering the fact that the plaintiff are in possession of the suit property, so the alleged sale deed was inoperative and ineffective.
Your this mortgage deed is also subsequent. It is of the year 1949.
1949.
Subsequent to execution of the sale deed.
Yes, 1949.
If you heard the learned counsel pleading on behalf of the appellant, the counsel for the appellant, this appeal has been filed against the judgment and decree dated 20/2/2023, within bracket decree signed on 4/3/2023 in civil appeal number 11 of 2020, passed by learned district judge Mam Hazaribagh, whereby the appeal has been dismissed. The trial court judgment and decree is dated 23/7/2014, within bracket decree signed on 4/8/2014, passed by learned civil judge within bracket senior division Government to Hazaribagh, entitled suit number 136 of 2006. The suit was dismissed and the appeal was also dismissed. Consequently, the plaintiffs are the appellants before this court in second appeal. The learned counsel for the appellant has submitted that though there are concurring findings recorded by both the courts, but the courts have not taken into consideration the impact of Exhibit 3, which is a certified copy of the deed of mortgage dated 27/5/1949, executed by Rupan Sahu and Pannu Sahu in favor of Babu Raghunath Prasad for 88 decimal of land in Khata number 56 in plot number 1823, 1824, 1857, 1890, 1892 and 2165 of village Hundu. The learned counsel submits that the very fact that there was a registered mortgage deed itself reveals that the title was still with Rupam Sahu and Pannu Sahu, and therefore the sale deeds executed, registered sale deed executed in the year 1932, 1939 and 1949 were forged, fabricated and void and not binding upon the plaintiff. the plaintiff claims to be the descendant of Rupam Teli and
Rupam, Pannu got issueless, Rupam.
Rupam Teli and the and Pannu Teli had died issueless. He submits that the courts have also dismissed the case on the point of limitation. After hearing the learned counsel for the petitioner, for the appellant, this court finds that the plaintiff had filed the suit for declaration of right title over the suit line described in Schedule B of the plaintiff. And also for the declaration that the defendant number 1 to 5 or anybody claiming under them have no right to interfere with the right, title, interest and possession of the plaintiffs. Further, through amendment, a relief was sought that the sale deed dated 7/6/1939, 11/9/1939, 18 and 18/12/1949, executed by Rupam Teli and Pannu Teli to Nirmal Teli, and also the sale deeds dated 1/10/1932 and 7/3/1932, executed by the same vendors to Videshi Teli, were forged, fabricated, inoperative and ineffective and not binding upon the plaintiffs. The specific case of the defendant was that the property in Khata number 56 was recorded in the name of Bhola Teli, name of three sons of Bhola Teli, namely Alag Teli, Bihari Teli and Gudba Teli, Guduba Teli, and sons of the elder brother Budhan Teli, who died prior to preparation of survey record of rights. The plaintiffs claimed themselves from the branch of Alag Teli, who had given a genealogy in which the defendant numbers 7 to 10 are the pro forma defendants. It was their further case that the recorded tenant Gudba Teli had no issue, and after his death, his wife shifted, and as such his interest and share merged with.
After death of his wife also.
And after death of his wife, he entirely shifted to the family of Alag, and as such his interest and share merged with Alag.
And that is an admitted.
Who became the absolute owner of the property of Gudba. It was further pleaded that separate Kabjawadi entries were made with respect to the recorded tenant, and in this case only the lands mentioned in Kabjawadi of Alag Teli and Gudba Teli were involved, which were given in Schedule A to the plate. It was stated that Alag Teli had two sons, Rupam Teli and Pannu Teli. And Pannu Teli died issueless, and the properties absolutely devolved upon the heirs of Rupam Teli, who are the plaintiffs and the defendant number 6 to 10. It was the further case of the plaintiff that they continued in possession as per Kabjawadi entry without any objection. With respect to payment of rent, it was pleaded that the same was being paid by the concerned defendants, which was being issued in the name of Jhari Teli and others. It was also pleaded that some sales were affected in the khatas and the rest of the land was in possession of the plaintiff out of the Kabjawadi land of Alak and Gurva. The cause of action arose when the defendant number 1 to 5 started laying claim over the portion of Schedule A of the plaint, and they disclosed that their ancestor Nirmal Sao had already purchased the land from the ancestor of the plaintiffs, namely Rupam Teli and Pannu Teli, and those lands were described in Schedule B of the plaint. It was also asserted that the defendant, that there was a panchayati call between the plaintiffs and the defendants, but the defendants evaded the matter. It was denied by the plaintiffs that their ancestors ever sold any portion of the land of Khata number 56 to anybody, and if such document is produced, the same would be forged, fabricated, inoperative, and conferring no title upon the defendants. It was asserted that they are in possession of the property for more than 100 years and were paying rent and had absolute right, title, interest adverse to the interest of anyone. The written statement was filed by the contesting defendant number 1 to 5, who denied the facts stated in the plaint and also asserted that the suit was barred by limitation and that the plaintiff had no cause of action. It was stated that the defendants admitted the recording, admitted the recording of the suit line as needed by the plaintiff and also the Kabjawadi entries in the Khatiyan mentioned in the plaint. They also admitted that the three brothers Alak, Bihari and Budva that there were three brothers, Alak, Bihari and Budva. Bihari died first, and as such the death of Budva, who died issueless, his interest devolved upon Alak Tel, who had two sons, Rupam Teli and Pannu Teli, who had inherited the property. However, they asserted that Rupam Teli and Pannu Teli sold the properties in Khata number 56 of their share in favor of Nirmal Teli and Videshi Teli through different registered sale deeds for valuable consideration during the period from 1932 to 1949 and put the purchasers in possession. And in most of the sale deeds, required permission from the Deputy Commissioner was also taken. It was pleaded that the defendants were the heirs and successors of Nirmal Teli and Videshi Teli, and who claimed to be in possession of the Schedule B property. The plaintiff had amended the plaint and had filed an additional, to which additional written statement was also filed. The plaint was amended so as to include the prayer challenging the sale deed of the year 1932, 1939 and 1949. While filing the additional written statement, apart from taking the point under that the suit was barred under Specific Relief Act and was also barred under the law of limitation, The learned trial court had framed the following issues for consideration, and the additional issue was numbered as issue number 7A, which related to challenge to the different sale deeds of the year 1932, 1939 and 1949. Both the parties exhibited oral and documentary evidences. The plaintiff had also exhibited some government rent receipts in the name of Jhari Teli and others for 5.85.66 acres, 6.63.10 acres and 6.80.10 acres and 5.82.66 acres respectively for the period from 2004 to 2011. And also executed a mortgage deed as mentioned above as Exhibit 3. The information was also received from the district record room that the Khatiyan of Khata number 56 was destroyed. The defendants also adduced oral and documentary evidences and filed numerous sale deeds right from Exhibit A to Exhibit A by 12 and also 22 original government rent receipts issued in the name of Nirmal Teli, Mahavir Teli, Jagdish Saw and Jhari Teli and others, which were Exhibit B to B by 21. The learned court recorded that the plaintiffs had filed the mortgage deed Exhibit 3, but there was no corresponding pleading in the plaint with regard to the mortgage deed. The learned trial court recorded the following facts and legal aspects with respect to the case. Page 37. The learned court thereafter, by recording the findings, and has specifically recorded that possession of the defendant with some hesitation over the suit property was admitted by the plaintiff number 3, examined as PW5. But the plaintiffs had not amended the plaint or filed any petition to stop the digging of the well. The learned court also considered the various sale deeds while recording the finding. And also recorded the inconsistencies with respect to the case of the plaintiff while considering the sale deed. And was of the view that even the suit properties, boundary of the suit properties did not tally with the boundaries mentioned in the sale deeds. While considering the issue number 3, the learned court has also recorded that the relief was sought for by the plaintiffs over Schedule B land were covered under different sale deeds of the year 1932, 1939, 1949, and this fact had come in the evidence of the defendant, who were found in possession, and they are getting the rent receipts. But no relief either of confirmation of possession or in the alternative for recovery of possession has been asked for, which made the suit bad under Section 34 of the Specific Relief Act. The court also recorded that the plaintiffs have not been able to prove that the sale deeds covering Schedule B land are not executed by Lupan and Pannuteli, and they were stopped from challenging the same. While deciding the point of limitation, the learned trial court held as follows paragraph number 12 quoted. Ultimately, the learned trial court has dismissed the suit. The learned first appellate court has also framed 2 questions for determination at internal page 12, and both the questions of determination have been decided against the plaintiff the learned court also recorded that the suit was the suit seeking the sale deeds as the suit challenging the sale deeds were barred by limitation. This court finds that the courts have recorded concurrent findings and the mortgage deed, which has been heavily harped upon by the learned counsel for the appellant during the course of hearing, has no bearing in this case inasmuch as there was no foundational pleading with regard to the mortgage deed. Otherwise, also apparently the suit property were sold by way of registered sale deeds of the year 1932, 39 and 1949 by the predecessor in interest of the plaintiff, namely Rupam Teli and Kunu Teli. This finds no merit in this appeal. Accordingly, the second appeal is hereby dismissed.
Item 61. Second appeal 170/25.
Anyone partition suit, earlier court below have granted partition suit in my favor. Thereafter, opposite party has filed the appeal and appeal initial against me.
Suit was decreed.
Decree.
The appeal, the court has reversed the finding. On what ground? Previous partition.
This position and we dismiss page 60 of federal suit order number 6, page 16. There is a wife of late Mahadev Saw was under my team with the late sale deed dated 11/11/1960, but Dhari servant died on 10/9/1960, before 2 months of the executed sale deed. So he TIE found that her TIE acquired 1,000 fabricated one. That basis settles degree in my favor.
The suit was for partition.
Partition. He said that
Where are the issues framed? Trial court.
trial petition. Commission number 1.
The sale deed was found to be forged. The sale deed of 1960 was found to be forged.
Good.
You have challenged the sale deed in partition suit.
In partition suit, I have challenged. I have knowledge after that, after filing this partition suit, he have knowledge on care.
No, in partition suit, how the sale deed was under challenge?
The sale deed is a challenge after coming the knowledge of this appellant. He challenged the sale deed. The whole thing has read in we see depreciate, we will like pursue.
Who had executed the sale deed? By grandmother.
Estate from Dhari Sawan, wife of is the one Y100 Mahadev Saw, grandfather. Yes, sir.
What are the issues framed by the trial court?
Issue that from the traffic. Issue number 1 and 3, page 52.
The entire property is covered by the sale deed.
Sale deed.
The entire property is covered by the sale deed.
Entire. Page 52. What is it?
Sale deed was executed by in whose favor?
Appellant and opposite party. Arrangement. Page 52, issue number 1 and 3. This as per the group 2 and 3, the suit property are the joint property of both the parties. The defendant number 1 right to establish the fact that there was a partition in the year 1932. Mahadev Shah used the site separately as mentioned in the Register of Sale Deed dated 11/11/1960 before C. But there is no written partition until unless there is no partition by meat and bound the family presumed to be a unit as there is no separate identity of a family to the undivided family merely residing separately or separate business for the convenience of the family or maintaining peace and harmony of the family does not mean there is partition by meat and bound. Even then they are joined by a step. The eldest member of the family will be the Karta of the family. Opposite party has admitted it is evident that after the death of Mahadev Shah, Lakshmi Shah, father of the defendant number 1, was the Karta of the family and managing the family affair. It is also a
So this property which was covered by the sale deed was taken to be a joint family property. What happened before the learned first appellate court? What did the learned first appellate court say?
In page 57, the cause of action of filing the present suit has been arisen first time in the last week of May 2009 when the defendant.
कहाँ से पढ़ रहे हैं? कहाँ से?
Page 57. Judgment of 57. Page 57.
Page 57 तो ट्रायल कोर्ट का जजमेंट है ना?
हाँ,
ट्रायल कोर्ट का जजमेंट देख लिया, appellate कोर्ट का judgment.
On the basis of discussion made here in the I am of opinion that the plaintiff has not been successful in proving that the sale deed number 374 dated 11/11/1960 before and C is a part of the declared document and the scheduled property is a joint property. The impute judgment degree part prepared by the trial court suffer dignity and the same are liable to be satisfied. Thus the point number 1 is here decided in favor of the appellant to be defendant first party. The judgment is hereby that this title is here allowed on content not cost. The parties shall bear their own cost. The impute judgment and degree passed and prepared by the trial court is hereby satisfied. The directive will be stipulated to be.
This deed, you have not been able to prove that it is forged and fabricated.
This is appeated order. I court order is this is the after death of vendor, this sale deed has executed.
Where is that finding that the sale deed was executed after the death of the vendor? Where is the finding that the defendant?
See, there is one page 53.
Page 53.
See, there is one family of the woman decision of the Sitaram, Ram, and there was no specific partition between the bond with regard to the true property, which was only the ancestral property of both the parties were the property purchased by the defendant number 1 by sale dated 11/11/1960. Is also a joint property as there is no evidence on the record that the sale property is his self-acquired property purchased by his own funds. Rather, the evidence has come by the defendant number 1 himself that he sold his mother to arrange the considered amount. Another assistant has also been taken by the defendant that during the time the defendant number 1 was facing the financial debt and to meet out of same he had leased out a big portion of the property to one local fund by the lease deed since 1989 to 2009, 20 years. For defendant number 1, during the entire lease period of land has been leased and collected by the defendant number 1, but the plaintiff and the defendant never objected the same. There is no any lease document of both the parties admitted the same. One is when the counsel for the plaintiff admitted that is the lease that till today the property is joint property and as a plaintiff and the defendant accepted the ownership of the cell number 1 being the Karta, where Papa as the eldest member of a family who is married, all the family affairs being the Karta and eldest member of a family he is out the property on his name and collected the land amount which they do not observe with their upon number 1 is managing the joint family property after evicting the Upal under when they thinking the former demanded the share then first time of defendant number 1 so then the alleged sale deed the day 11/11/60 and they first time came to know about the existence of the sale deed. The 9th. It is settled on the Hindu family continues to be a joint family if it is joint the shares of food or sea will stay however if a family is not joint in food and or sea even if they live separately they constitute a joint Hindu family provided they are joint in the state a joint Hindu family is neither a son or a person as they do not have a separate legal entity from that of its member. It is a unit and is represented by the Karta of the family in all matters. Karta means manager of the family property. He is the person who takes care of the expenses of the family, looks after the family and protects the joint family property in the entire Hindu joint family. Karta manager plays a very important role. Isha Karta is usually the single most male member of the joint family and he has the power to control the whole business. Mulaya family is joint, then the judge in the status among the members of a joint Hindu family by the refinement of share which is called division in status or an equal division in status and equal division among them by allotment of property to each one now which is described as division by bond or partition partition not acceptable before the amendment in 2005 and all partition was publishable with the burden of proof on the person who claimed there was a verbal revision for the amendment. Date 66 5 of the Hindu Succession Act say a partition can be effected by any registered deed or a court degree. A plea of oral partition may be proved by either deposing the beneficiary of such partition or those implicated with the same, which generally involve cash and other related inappropriate essay, even the revenue relied upon to support the plea of oral partition. But here in the project, should the defendant fail to prove any previous partition or insist on behalf of the late Mahadev Saab, the defendant further failed to
See, the core point is as to whether there was any whether this particular sale deed of the year 1960 was valid or not, because the entire property is covered by 1960 sale deed.
96 sale deed.
Right, the entire property is covered by 1960 sale deed.
After death of
कहाँ finding है कि after death? कहाँ आप
16 में है?
Page 16 पढ़ी? Page 60, just a minute.
So, that is now what gender
Page 60, just a moment. Page 60 में तो ऐसा
16
16 ये फाइंडिंग थोड़ी है, आपका तो प्ली है. Where is the finding? Where is the finding on this? I was not able to get any finding. There is no finding. The deed was executed prior to her death. कहाँ कोई फाइंडिंग है that deed was executed prior to her death?
जानकारी दिया हुआ है कि the defendant number 1 so clearly thus was executed the sale deed dated 11/11/1960 without any delay. Therefore, just after the next date of the order dated 10/11/1960 in the case number 3560, but on the contrary, he was denied select of his mutation in his favor of say since 1960.
एक लाइन दिखाइए ना, पूरा क्या पढ़ रहे हैं? That the sale deed was executed after her death. Show me one line. There is no finding.
From the school, it can simply concluded that the registered sale deed number 274 is required, illegal, and required to be concealed, and hereby concealed. This court has no option except.
अरे भाई आपसे जो पूछ रहे हैं या तो आप उसका जवाब दीजिए. Where is the finding that the sale deed was executed after her death? There is no such finding. You read from page number 73. Point number 1.
Was that?
अरे भाई आपका प्ली था, प्रूफ तो नहीं किया ना. What is the date of death?
Date of death है 10/9/1960. Exhibit 1.
That is exhibit 1. What is the date of death?
10/9/1960.
ये तो डीड का डेट है ना.
डीड का नहीं, डीड का डेट 11/11/1960, 2 महीना बाद.
कहाँ है फाइंडिंग? क्या प्रूफ किए हैं? फाइंडिंग दिखाइए. फाइंडिंग केस मत दिखाइए.
51 में in such circumstances the plaintiff has succeeded to establish that the vendor number 2 from Dhari Soman was died on 10/9/1960 at the time of execution of the sale deed dated 11/11/1960. 51 second पहले मर चुकी है 2 महीनों.
और एप्लेट को क्या फाइंडिंग दिया? एप्लेट को
एप्लेट को on the basis of discussion made here, I am on opinion that the plaintiff.
You come to page number 76 of the appellate question. Roman 7 पढ़िए. Roman 7.
So,
The plaintiff has challenged.
challenge the guide the units of the state salary on 2 points. Firstly, Ramdari Savan number 2 of the state salary had already died on the small Mississauga before prior to its execution number 11/11/1960. And as such, the LPI on the state salary is what? He had filed the death certificate of the Ramdari Savan in support with the intention that she had died on the Mississauga. The result of SB number 1 shows that it was issued on 8th November. After about 59 years of her death and merely 18 days before filing of the petition, and that too by the Panchayat Sevak of Urban Panchayat, the records of death person has to be duly reported to the concerned register, the sub-registrar within 21 days of their occurrence. However, Section 33 of the Registration of Births and Deaths of 1969 stipulates that any birth or death which had not been registered within 1 year of its occurrence shall be registered only on an order made by a magistrate of the first class or a agency magistrate after verifying the correctness of the birth, death, and on payment of the prescribed fee. Nothing has been brought to show that the order of the magistrate was obtained before issuing the said death certificate. Similarly, nothing has been brought on record to show that the Panchayat was competent to issue the said death certificate, and therefore the death certificate will become doubtful. Another contention of the plaintiff that on the 11th date of execution of said deed number 1974 to date 11/11/1960, Ram Nasar was a minor. Hence, he was not competent to execute any document in his own capacity. Also, stand falsified by the sale deed number 222 of 1959 dated 20 toward 1959 executed by the Jharkhand wife of Mahadev Shah in favor of the Ramnath Shah Ministry of sale deed number 18/72/60. In the process sale deed, it is now mentioned that the Bhindi Ramnath Shah was the minor on the recital of the said sale deed shows that the Bhindi had paid to be 300 cash to the vendor as consideration amount. The plaintiff has failed to explain as to how Ramnath Shah could become a Bhindi in his personal capacity in the said sale deed when he was a minor of 11/11/1960. Thus, it is evident that the plaintiff has failed to prove that the sale deed was 1874 but dated 11/11/1960 before it was adjudicated. Once the said sale deed is here held to be genuine, the plaintiff claim of share in the suit property becomes unsustainable in law. The plaintiff has also failed to prove that no consideration amount was paid to the vendors by the Bhindi that sale deed. Further, the plaintiff has failed to prove that the said sale deed is false and fabricated. It could not have been challenged beyond the period of limitation stipulated under Section 59 of the Limitation Act. The law in which that once the sale deed was registered, it was presumed that it can known to everybody, including the vendor, in view of the Section 3 of the Transfer of Property Act, and no suit was filed for cancellation of the sale deed within 3 years. Hence, the present suit is now barred by limitation. The alleged date of knowledge of regarding the
Your only document in connection with the date of death was the exhibit 1, right? That is the death certificate. The death certificate was also issued after lapse of long years.
आपने ये नॉलेज और 2009
उसके बाद आप डेथ सर्टिफिकेट लेने गए थे।
नॉलेज उसको होगा कि जमीन इससे लीड किया आपने
तो उसके बाद डेथ सर्टिफिकेट खोजने गए। डेथ सर्टिफिकेट इशू करने का कोई सिस्टम है ना? The learned appellate court has recorded that there has to be a proper inquiry while issuing the death certificate. No inquiry was conducted. If a death certificate is issued after 18 years of death, then that death certificate is of no value unless the inquiry is conducted as per law. So that death certificate has been disbelieved by the court. So apart from that, what other evidence is there? There is no other evidence showing that she has died. इसके अलावा तो कोई एविडेंस नहीं है ना? I heard the learned counsel appearing on behalf of the appellant. This appeal has been filed against the judgment dated 19/11/2024, within bracket decree signed on 2/11/2024, that it was passed in civil appeal number 21 of 2022, passed by learned district judge Roman Devkar, by which the appeal has been allowed. And the judgment dated 7/5/2022, within bracket decree signed on 17/5/2022, passed by learned civil judge within bracket senior division Roman Devkar, entitled within bracket partition suit number 17 of 2009. The title suit was decreed and the appeal was allowed. Consequently, the plaintiff is the appellant before this court. The learned counsel for the petitioner appellant has submitted that the bone of contention between the parties was with regard to the registered sale deed dated 11/11/1960, and the entire property is covered by the said sale deed. The learned counsel submits that the sale deed was challenged to be forged and fabricated in as much as the grandmother, the executor of the sale deed, had expired on 10/9/1960, and the sale deed was executed on 11/11/1960. The learned counsel has also referred to the trial court judgment and I submitted that the trial court held that the plaintiff had succeeded in establishing that the vendor number 2 of the sale deed, namely Ramdhari Shravin, Shavain, died on 10/9/1960. By virtue of Exhibit 1, which was the death certificate, and therefore she had expired prior to execution of the sale deed, dated 11/11/1960 within bracket Exhibit 4 and C. The court had also recorded that Ramnath Shah, who was the co-executor of the sale deed, was a minor at the time of execution of the sale deed. The learned counsel submits that on the basis of the foresaid two findings, the learned trial court had declared the sale deed as void, illegal, and required to be cancelled. And the issue was decided in favor of the plaintiff. The learned counsel has further submitted that the suit property was joint property of both the parties, and the defendant number 1 tried to establish that there was a partition in the year 1932, and Mahadev Shah used to reside separately, as mentioned in sale deed dated 11/11/1960 within bracket Exhibit 4 and C. But there was no written partition, and unless there is a partition by metes and bound, the Hindu family is presumed to be a unit and an undivided Hindu family. Mere residing separately or having separate business or convenience does not mean that there was partition by metes and bound. The learned counsel has also submitted that DW3, Kanai Shah had admitted in his evidence that after death of Mahadev Shah, Lakshmi Shah, the father of the defendant number 1, was the Karta of the family, and he used to manage the family affairs. And admittedly, Mahadev Shah died on 28th of December 1915, leaving behind his 2 widows and minor Ramnath Shah. The first 5, namely Ramdhari Shravin, died issueless, and after death of Mahadev Shah, both the widows were living separately, and they were not in good relations. The learned counsel submits that even as per the trial court judgment, the sale deed was a joint property and there was no evidence on record that the said property was the self-acquired property purchased by defendant number 1 from his own fund. Rather, the evidence has come that the defendant number 1 himself has said that he sold his mother's ornaments to arrange the consideration amount. The learned counsel submits that the trial court judgment has recorded that not only the sale deed was forged and fabricated, as one of its vendor had died prior to execution of the sale deed, but had also recorded that the property was a joint family property. He submits that the learned first appellate court has wrongfully reversed the findings and consequently a substantial question of law will be framed after admitting this second appeal. Order on the point of framing substantial question of law is reserved. देख के order करें.
Household case item 59, second appeal 67 of 2025.
क्या बोले? Second appeal number 67 of 2023. Nobody appears on behalf of the appellant. By way of last indulgence, closed this case on 3rd of August.
Item 62, second appeal 189 of 2025.
Please.
May it please your Lordship. Lord, as against the reversal and
Appeal has been partly allowed.
partly allowed law. It was a case for partition. Now, there were several scheduled lands in the plaint. As regards Schedule A and B, the appellate court up ahead. The judgment of the trial court, shares were granted
to the common ancestors which we all are not the plaintiffs and the defendants. As regards A and B, partially allowed. Now,
The A and B was partially allowed.
No, upheld.
Upheld.
I'm sorry. Upheld, and therefore appeal was partially allowed. And as regards, my lord, the schedule C to K. Now, the appellate court commits an error of record by saying, by observing, Lord, that as regards schedule C to K, the plaintiff has not given description of the recorded tenants, which is an error of record. Para 7, 8, 9 and 10 of the plaint speaks that.
What is the evidence? You have exhibited the record of rights.
हाँ, record of rights में सब exhibited है.
कौन सा exhibit? बताइए. Which exhibit? Let us see the finding of the learned first appellate court. Refusing. Para number 28 पढ़िए ना सर.
हाँ, वही.
Para 28 appellate court.
So far as the allocation of share of schedule C to K is concerned, as the whole appeal brought before the court for hearing, I have gone to the judgment passed by the learned court of principal district judge, being appeal number 5 of 2020, on which remitted back to the learned trial court subject to a fresh consideration. The court mentioned in para 19 of the judgment that respondent plaintiff have not come with clean hand and have not mentioned in their claim that which plot of these scheduled property are in whose name. After perusal of Parcha filed on behalf of the plaintiff, the name of the recorded tenant, Dinu Mia, Kodo Bibi, Noni Bibi, and Yasin Bibi. I just pause, Lord, and bring to your lordship's notice कि हम लोग दीनू मियाँ से हैं और यासीन से, लास्ट में यासीन है, यासीन से लॉर्ड डिफेंडेंट्स, और दोनों भाई हैं, माने यासीन एंड लॉर्ड दीनू जो हम लोग हैं, they both were full brothers, और दो भाई और थे जिनकी ये दो विडो हैं. So total 4 brothers were there. Recorded tenants में जो genealogy आई है, not 4 brothers, जिसमें कि 2 विडो हैं, कोदू बीबी और एक और नाम आया नोनी बीबी. Now I proceed further. Recorded tenant दीनू मियाँ जो हम लोग हैं, कोदू बीबी and नोनी बीबी, they both died issueless, and यासीन बीबी जो defendants के हैं, find mentioned in the rest scheduled properties. But the entries made in there is several cuttings in respect of holding of recorded tenant. Further, that schedule C to K are not prepared as per the Parcha, that those property, and in every schedule there is no specific name of the recorded tenant given by the respondent plaintiff. Not this is an error of record. शेड्यूल में हम लोगों ने जेबी नंबर और प्लॉट नंबर सब मेंशन किया है, लेकिन पैरा 7, 8, 9 एंड 12 में स्पेसिफिक रिकॉर्डेड टेनेंट्स का जिक्र है और ट्रायल कोर्ट से भी जाहिर होगा हमारा. इसलिए ट्रायल कोर्ट ने भी, क्योंकि कुछ प्रॉपर्टीज पर्चा के अनुसार जॉइंट है और कुछ सेपरेट जो यासीन के नाम से है, जो डिफेंडेंट्स मिलॉर्ड एयर्स ऑफ यासीन, तो यासीन के नाम से कुछ जो प्रॉपर्टी थी वो एक्सक्लूसिव एब्सोल्यूट उसके नाम से है, जिसको लेकर हम लोगों ने क्लेम भी नहीं किया है. Which has come
There
by
was an order of remand, no?
Pardon?
What was the scope of remand? Remand का scope क्या था? Where is the order of remand?
वो अपरेट कोर्ट ने उनको रिमांड किया था कि एक बार फिर से
नहीं, पूरा ओपन रिमांड नहीं है. Where is the order of remand?
अपील नंबर 5 of 2020. Five of 20. Remanded. I'm having.
तो क्लियरली उसमें लिखे हैं कि कोई बेसिक एविडेंस प्लीडिंग कुछ नहीं है. But still an order of remand was passed. There is a clear finding rather. Whereas in property C to K, in absence of clear and supportive pleadings, the finding returned by the learned trial court declaring 5/32 shares in favor of the respondents was not tenable under law.
इतना from our plain Lord, we have quoted verbatim plain, जिसमें मेरे petition का में देखा जाएगा. There are 7, 8 and 9 में Lord specifically we have stated कि कौन सा absolute करके पर्चा में रिकॉर्डेड है इन द नेम ऑफ यासिन.
पर्चा में जो कटिंग है इसीलिए तो कोर्ट उसको माना नहीं है ना सर. बहुत कटिंग है आपके पर्चा में. The courts have discarded that evidence. There is a discussion that the courts have discarded these evidence. But the entries made, there is several cuttings in respect of holding of the recorded tenant. Further, Schedule C to K are not prepared as per the Parcha, that those property, and in every schedule there is no specific name of the recorded tenant. Parcha में recorded tenant का नाम है, वो तो cutting है, और आपके plaint में है.
हाँ plaint में है.
कि किस कौन सा property किसके नाम से है?
सब specific दिया हुआ है my lord.
कहाँ है plaint में आपका?
Lord, kindly see Lord my petition verbatim quoted not the plaint. Synopsis में स्टार्ट ही होता है synopsis से, तो उसका second, third page synopsis.
verbatim we have quoted the plaint clause. इसमें second page में देखेंगे बिंदु plaint copied verbatim from para 1 to para 25 और para 7 से उर्दू देखा है पर्चा में किस का नाम एब्सोल्यूट करके है वो सब दिया हुआ है और किसका कौन से पर्चा में जॉइंट इसको लेके कहीं पर डिनायल भी डब्ल्यूएस में नहीं है क्योंकि जॉइंट जो पर्चा अगर है तो उसी तरह से शेयर हो जाएगा जॉइंटली और जो सेपरेट यासीन के नाम से है दैट वी हैव फॉरगॉन आई मीन वी आर नॉट क्लेमिंग जो आया भी है ट्रायल कोर्ट के जजमेंट में
You are only concerned with C to K.
C to K और A and B भी A and B में भी शेयर सबका अलॉटेड हो गया
वो तो आप जीते क्या ना उसमें
तो ऑन दी वन
फॉरगॉन काम किए
Pardon?
आप तो उसका पार्टीशन क्लेम कर रहे थे आपको मिल गया ना
हाँ A and B का मिल गया
हाँ मिल गया तो आप फॉरगो थोड़ी कर रहे हैं आपको तो मिल गया
हाँ A and B मिल गया
C to K नहीं मिला
C to K को इन्होंने ट्रायल कोर्ट के जजमेंट को सेटिस्फाइड कर दिया जिसमें शेयर्स आपस में जॉइंट मानते हुए दिया गया A and B में दिया गया the appellate court upheld that as regards schedule A and coming from the same ancestor the same purchase इसमें Para 7 में ही schedule A absolute in the name of Sheikh Dinu. उसके बाद joint है B C.
After hearing the learned counsel for the appellant, this appeal is admitted for final hearing on the following substantial question of law. Plain written statement है आपके पास? ये आपका फर्स्ट सब्सटेंशियल क्वेश्चन ऑफ लॉ बना देते हैं इससे हो जाएगा आपका पॉइंट नंबर 1 से हो जाएगा आपका देखिए पेज नंबर 6
मिलोड
हो जाएगा इससे
मिलोड और दूसरा भी बना देंगे मारो C and K जब A और B उसी कॉमन एंसेस्टर सब पर्चा सब है A और B में आप दे रहे हैं C and K में एकदम आप कर दिया कि नो blowing hot and cold blood at the same time
3 बना दे 3 बना दे
मिलोड
1 and 3 ठीक है
मिलोड
3 चेक कर लीजिए
मान
हो जाएगा
मिलोड
issue notice to the respondents for which requisites कहाँ के हैं ये
सब जामताड़ा के डिस्ट्रिक्ट अब तो जामताड़ा ही होगा
कोई वहाँ के भी हैं बर्धमान डिस्ट्रिक्ट पे बर्धमान तो वहाँ पड़ेगा ना वेस्ट बंगाल में बर्धमान
हाँ बर्धमान तो बंगाल है तो बंगाल में भी इधर बंगाल बंगाल वेस्ट बंगाल
पश्चिम बर्धमान स्टेट भी नहीं लिखे हैं आप पिन कोड नहीं लिखे हैं
इम्पोर्ट के साथ हम लोग कर देंगे।
For which requisite under speed post be filed within a period of 15 days from today. The Council for the Appellant has undertaken to provide complete address, present and complete address of the respondents,
With PIN code.
including their PIN code. With the records we call for from the concerned court. इसको रख लीजिए.